My client lacks memory as to whether, as to the circumstances of the stop. He was a .30 at the time, so he can establish the factual basis as to the where, the when, prior convictions. But Deputy DeRusso was in fact the officer that stopped him, and we would propose that he testify to establish that portion of the factual basis. The agreement is that my client would plead to the charged offense, OWI third, with an agreement for a sentencing cap of 6 months, and the people have agreed not to seek or advocate for bond revocation following his plea today.
Okay, and do we have a written agreement? We can certainly take testimony to establish a factual basis, but also I think we already did. Would there have been, we had an evidentiary hearing in this case.
There was, Your Honor. I do have the transcript here.
Yeah, looking at my notes, I'm not sure we ever got into the level. If you have the test results, you can just mark that as an exhibit, and if there's no objection to its admission, I can supplement the defendant's statement with that as factual basis.
No objection to that. The issue is actually going to be the basis for the stop.
That's not even really necessary to take a plea, right?
Okay. Well, I mean, an element is that he was operating a motor vehicle, so we have to establish.
Oh, he can't.
He couldn't remember if the vehicle was running or not, among other things. And so,
is it perhaps simpler to take a no contest plea for lack of memory?
I think that's probably the simplest way, Judge.
Okay. And for a factual basis, I can take judicial notice of the prior hearing at which I presided, and if you supplement that with the test results, I'd be satisfied.
Yes, Your Honor, and to be clear for the record, that hearing was on April 22nd of 2024.
All right, do you have a copy of the test results you can mark?
I can go and make a copy, Your Honor.
Is that something you have a soft copy of that you can just write your own copy later and just mark yours now? Do we have a written plea agreement, Mr. McClellan?
Working on it, Your Honor.
Sure. And do you have the advice of rights forms? Yeah. Mr. Boyd,
Right.
Let's go off the record for a second.
Yes.
Do you understand that?
Yes, I do.
Is that what you want to do today?
Yes, I will. Yes.
All right, the plea agreement provides an exchange for your plea of no contest to the OWI third. The prosecutor will dismiss the remaining counts. There's restitution set at $200 for an OWI reimbursement, and there's a sentence agreement for a 6-month jail cap. Do you understand the terms of that agreement?
Yes, I do. Yeah.
Mr. Boyd, is that a full, fair, and accurate statement of his terms?
It is, Your Honor.
Mr. McClellan?
Yes, Your Honor.
Mr. Kubik, that sentence agreement for the 6-month cap, that's not binding on me. At sentencing, if I wanted to give you more, I wouldn't have to follow this. But if I wanted to give you more than 6 months, you would be allowed to withdraw your plea, not having received what you bargained for. Do you understand that?
Yes, I do.
There is an important exception to that rule. If you engage in some misconduct between now and the sentencing, say you violate a court order, conditions of your bond, you don't show up for court, you abscond on your bond, or you commit a new crime, anything like that would cause you to lose the right to withdraw the plea, even if I didn't follow that agreement. Do you understand this?
Yes, I do.
Now, Mr. Kubik, if I accept this plea, you give up any claim that it was caused by any promises or threats that aren't placed on the record today. Do you understand that?
Yes, I do.
And also, any application, any appeal, you have to get permission to appeal, which you seek by filing an application. And the types of issues that you could raise on any appeal after a plea are very limited, much more limited than if you were convicted after trial. Do you understand that?
Yes, I do.
All right. Other than this, the terms of this plea agreement, has anybody promised you anything to get you to plead guilty?
I'm sorry.
Has anybody promised you anything else to get you to plead guilty beyond the plea agreement?
No.
Has anybody threatened you to make you plead guilty?
No.
Is it your own free choice to enter that plea?
Yes, I am.
Knowing all this, how do you wish to plead to the charge of operating while intoxicated, third offense?
No contest.
All right, and based upon my judicial notice of the previous hearing and reviewing Joint Exhibit 1, I do find a factual basis for the fact that Mr. Kubik was operating a vehicle on a public highway after having consumed alcoholic beverages, and that was above the legal limit. In fact, it was above the high BAC limit. I do need to ask you, Mr. Kubik, about your prior convictions. Did you have a conviction for operating while impaired in 2019 in the 88th District Court?
Yes, I did.
And did you have 2 convictions in 2022 for operating while intoxicated or impaired? One looks like in the 23rd Circuit and one in the 81st District.
Yes.
And did you have an operating intoxicated 2023 in the 81st District?
Yes.
Okay.
One of those in 22 was dismissed.
Okay, so maybe it was only 1 instead of 2.
Yes, yes,
Okay.
yes, yes.
Right, and that still would be sufficient for the third offense notice. Mr. Voigt, are you satisfied with the factual basis?
I am, Your Honor.
Mr. McLennan?
Yes, Your Honor.
Mr. Voigt, are you aware of any other promises, threats, or inducements?
No, Your Honor.
Mr. McLennan?
No, Your Honor.
Mr. Voigt, in your judgment, has the court fully complied with the requirements of 6.302?
Yes, Your Honor.
Mr. McLennan?
Yes, Your Honor.
Here, Mr. Kubik, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe you're guilty of that offense. So I hereby accept your plea. We'll schedule sentencing for September 8th, 10:30 in the morning.
September.
I'm going to order you to cooperate with a pre-sentence investigation. So you have to meet with Agent Lesky, get her card or before you leave the courtroom so you can contact her to schedule an appointment. You have to cooperate with an interview so she can write a report so I know more about you than what I just learned today and at that previous hearing, right? So we can make a good decision about a proper sentence for you. And there being no objection to continuation of bond, I'll go ahead and continue bond.
Thanks, Your Honor.
All right, let's talk about that. People v. Kubik was a classic example of how a courtroom handles a difficult case with a calm hand and clear legal guardrails. The charge was operating while intoxicated, owie, third offense, serious business, and Mr. Kubik entered a no-contest plea. Judge Aaron J. Gauthier oversaw the proceeding with his usual blend of legal precision and procedural fairness. Defense attorney Mr. Voida was up front. His client couldn't recall many details of the stop due to a blood alcohol level of 0.30. That's not a typo 0.30 at that level. Memory gets fuzzy, and with his client unable to confirm the elements of the charge, Mr. Voida proposed a no-contest plea, citing lack of memory. The court agreed that was the cleanest route, especially since they had a prior evidentiary hearing on the record and lab results on hand to supplement the factual basis. Judge Gauthier carefully confirmed that the no-contest plea was voluntary, that Mr. Kubik understood the implications, and that the sentencing cap of 6 months in county jail part of the plea deal was not binding on the court. If the judge wanted to go beyond that cap, Mr. Kubik could withdraw his plea, unless, of course, he violated any court orders in the meantime, in which case the deal would be off the table. Kubik answered every question with a steady yes, showing he understood exactly what was happening. The judge then went over his prior aware-related convictions, 2019, 2022, and 2023, even after noting that one 2022 charge had been dismissed. There were still enough on the books to qualify this one as a third offense, both counsel. Mr. Vida and prosecutor Mr. McLennan confirmed there were no additional promises, threats, or inducements beyond what was on the record. With that, Judge Gauthier accepted the plea, ordered a presentence investigation, and scheduled sentencing for September. He reminded Mr. Kubik to connect with Agent Lesky for the interview so that the court could get a better understanding of his circumstances before making a final sentencing decision. Overall, this was a low-drama hearing but a high-stakes moment for the defendant. Judge Gauthier moved through each step methodically, ensuring that due process wasn't just followed, it was respected. Mr. Kubik seemed to grasp the gravity of his situation. With a BAC that high and a record to match, there's no room left for slips. The judge's tone made it clear. The door to rehabilitation isn't closed, but accountability is non-negotiable. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.